Akira has responded to Brenay's motion to delay enforcement of her judgment in the amount of $1.75 million. It's a little spicy. It has some photo receipts, including some mentions of Tamron Hall. Let's break it down. As always, I am a certified law nerd, bona fide non-attorney. This is not legal advice. Let's begin. The response starts by making something crystal clear. In North Carolina, appealing a money judgment does not automatically stop collection. A stay only happens if the defendant complies with Rule 62D and actually posts a court-approved undertaking under NC General Statute 1-289. In my video covering the motion, we talked a lot about what that would look like, the conditions that would need to be met, what the court is being asked to do, so feel free to check that out. As of now, that has not happened. There is no bond, there is no surety, there is no court approval, which means legally speaking, the judgment is still enforceable. In the second point, the defense argues irreparable harm if collection moves forward, and the response pushes back hard on that. North Carolina treats money judgments differently from injunctions. Financial loss alone is not irreparable harm because money can be repaid or restored if the appeal succeeds. That's black letter law, and the response is reminding the court of that. This is important because it's undercutting the urgency argument for an unsecured stay. The next point is that the bond exists to protect the plaintiff, not the defendant. We talked about this in the last video. The response explains why the bond requirement exists in the first place. It's not punitive, it's protective. The undertaking is there to ensure that if the appeal fails, the plaintiff can actually collect what the jury awarded, including post-judgment interest and costs. And those costs continue to accrue during the appeal. Any bond has to cover that as well. Quick reminder here, even though a bond is not a win for the plaintiff, it definitely safeguards the plaintiff. It's not a shortcut, but it is definitely protection for Akira. In the next point, Attorney Robin also makes a very strong prejudice argument. This judgment is final. A jury verdict was entered. Enforcement has already been delayed by post-trial motions and the appeal itself. Further delay without security increases the risk that the assets are dissipated, encumbered, or made harder to reach. In other words, she's spending all her money, and there's evidence that we're going to show in just a second, while the plaintiff continues to incur legal costs responding to these appellate filings. I really appreciate this reframing because it's pointing out that even with a successful bond process, this is still costing Akira time and money to litigate. And then we get to the exhibits. The response attaches publicly available social media posts, including travel, shopping, media appearances, and monetized content, all offered to rebut the claim that immediate enforcement would be unfair or devastating. The argument is simple. You cannot claim financial catastrophe on one hand while publicly documenting discretionary spending and income on the other. Let this be a lesson that anything you say or do, even online and on TV, can be used against you in a court of law. So what happens next? Procedurally, this is likely what the judge was waiting for to schedule a hearing. Once the hearing is scheduled, the court will likely decide if a stay is appropriate, and if so, what the bond amount and requirements are going to be. Until then, the judgment remains in effect. A quick reminder here that should the stay be granted, that would come along with the supersedious bond. That bond is meant to protect Akira throughout this process, and although that protection is there, that doesn't necessarily carve out a happy path for Akira. After all, the happy path would be the defendant would stop relitigating this and just pay her judgment. Now she is having to incur legal costs, waste more time in court, having to maneuver the appellate part of this process. So it is still frustrating, and of course, her attorney is going to defend her position and ask that the court deny it to begin with and allow them to collect. However, I want to mention again, should this move forward and the stay be granted, there is some protection for the creditor. With that said, we're going to continue to monitor the docket, and as soon as a hearing is scheduled, I will let you know. I'll catch you in the next video.